This is Metin Çorabatır, and we shall start the session before the last one, I think. Huh?
This is the last one.
This is the last one. I see. Oh, it's an honor to have. So we have a panelists, three panelists. One will join us from distance from Rivers State University. So hello again, Mr. Michael Ogwezi. Is it correct pronunciation? Michael?
Yeah, so can I start with my presentation?
Professor Michael, not yet.
Okay, thank you.
And to the left, the Associate Professor Dr. Işıl Acıhan from Nevşehir Hacı Bektaş University, and far left to me, Miss Doctor or PhD candidate Dilahan Bice Kurtoğlu. Welcome.
Okay, so the floor is for me now.
Yes, Professor Michael. Thank you.
All
for
right,
your
thank you
patience.
very much. Like I said earlier, that I'm very grateful to the organizers of this conference who gave me the singular honor and privilege to present my paper online, because I understand that the conference was meant for in-person presentations only, but they were very magnanimous to avail me that opportunity, and I'm not taking it for granted. Hence, I'm being very grateful. My paper is on comparative asylum rights, exploring the tensions between the European standards and the African frameworks. In this paper, we're going to look at the European standards, that's the law regulating asylum seekers in the European Union, and the law also that deals with issues of asylum and refugee seekers in African countries. We are going to look at the law in terms of the regional legal standards. You know, we're not going to look at the individual laws of each European country or each African country, but the law that all these countries in Europe abide by and all the countries in Africa abide by. So by way of introduction, this paper addresses the rising wave of international migration. Currently, the figures show that an estimated 122 million people are forcibly moved across the world. This paper undertakes a comparative analysis of asylum rights granted under the European Union standards and those granted under the African regional law. It highlights normative, procedural, and practical efficacy, particularly considering the increased pressures of migration on regional asylum systems, with reference to the 1951 UN Refugee Convention, which came into operation in 1954. The paper engages in comparative analysis between the European Union's supranational harmonization of refugee policies and Africa's unique paradigms of cooperation and solidarity. A refugee is an individual who fears persecution on grounds of race, religion, nationality, social group, and political opinion. The 1967 protocol to the 1951 UN Refugee Convention ensures that the principles, rights, and obligations established by the 1951 Convention are enjoyed by all, regardless of geographical scope, which originally defined as being limited to Europe. Initially, the 1951 UN Convention was meant to regulate issues of refugee and asylum in Europe. You remember that in 1951, as at 1951, most countries in Africa are still not are still not independent, so they are not parties to the 1951 convention. And I also believe that most countries in Asia are not independent. They were still under the subjugation of the European powers such as Britain, such as France, such as Portugal, such as Belgium. So they were not privileged to be part of the 1951 UN Convention. So in 1967, a protocol was made, and that protocol is another international instrument made to cover the gaps in the 1951 convention. There is a record high number of forcibly displaced people around the world, with 122.6 million people displaced by mid-2024 due to persecution, conflicts, violence, human rights abuses, or events seriously disturbing public order. The figure dropped to 117.3 million by 2025 due to the returns from Syria, Sudan, and Democratic Republic of Congo and Afghanistan. In Africa, nearly 13 million people who face displacement in West Africa alone constitute about 48% since 2020. The methodology adopted for the purpose of this presentation is a mixed methodology, but basically it's normative foundations that examines doctrinal analysis of foundational treaties. That's the 1951 Convention, the 1967 Convention, and the 2009 Kampala Convention that deals with the state of refugees in Africa. Again, procedural safeguards receive scrutiny by contrasting the EU Qualification Directive of 2011 and the Asylum Procedures Directive of 2013, which mandates subsidiary protection, accelerated procedure, appeals, and judicial review. The EU standards is compared with the African legal frameworks, which emphasize on mass influx, accommodation, and IDP duties, highlighting gaps in enforcement mechanisms like EU adjudication versus the European Court of Justice litigation. That's where the European Union adjudicates on issues relating to migration. Now into the main work, the African legal instruments on migration. The Seminal Organization of African Unity Convention governing the specific aspects of refugee protection in Africa, that's the OAU Convention, adopted on 10 September 1969 and entered into force in 1974. It built innovatively upon the universal standards of the 1951 Convention and the 1967 Protocol relating to status of refugees, with limited definition of refugee as those individuals fleeing persecution and ensuring non-refoulement without geographical limits post-1967. The OAU Convention extends refugee status to include persons who are obliged to leave their country of origin owing to external aggression, occupation by maybe foreign powers, foreign domination, or events seriously disturbing public order in adjoining states. Complementing the OAU Convention is the AU Convention on the Protection and Assistance of Internally Displaced Persons in Africa, that's the Kampala Convention, which came into operation in 2012, and closes a gap in the protection not covered by the 1967 and the 1951 UN Convention. And it binds on all African states with particular regards to internally displaced persons. There's a clear distinction between internally displaced persons and asylum seekers. Asylum seekers are usually those persons who move beyond their borders, who move from one country to the other. But IDPs are persons who are moving away from one community within the country they live for the sake of maybe crises such as internal war, displacement as a result of natural disaster, and so on. So that's the clear difference between the Refugee Convention and the 1969 EU Convention. You know, immigration governance in Africa is also subject to non-binding EU policy instruments such as the Migratory Policy Frameworks for Africa 2006 that is revised in 2018, which facilitates harmonized labor migration, border management, irregular migration control, and migrant rights, in addition to the African Common Position on Migration and Development. For the benefit of doubt, our paper is not going to deal with the migration policy framework of Africa. We're rather going to look at the laws, which are basically the OAU Convention of 1969 and the 2009 Kampala Convention, because we're basically looking at issues of law. These instruments reflect African solidarity, voluntary burden sharing, though still have implementation problems due to availability of resources and weak adjudication deficit. So now we're going to look at the European standards and the key legal anchors. Under the European standards, we are going to look at the Common European Asylum System, which came into being in 1999. I'm very sorry, I don't know, maybe I skipped it. Be sure that... Okay, the European asylum system, the law regulating it is the Common European Asylum System. It consists of 10 laws governing asylum in the EU. And it provides the definition of the right of seekers before and after receiving protection, which country is responsible for dealing with asylum claims, and the providing protection, which is the core of asylum and migration management regulation by virtue of Article 67 and 78. As part of reform, the Common European Asylum System became known as a New Pact on Migration and Asylum in 2024, after 8 years of negotiation. It has a transitional period of 2 years and will become operational in the summer of 2026. So by virtue of this presentation, we are relying on the Common European Asylum System that's in place in 1999, because we are yet to hit the summer of 2026. Now, we are moving to the Common European Asylum System. It is grounded on 5 key Dublin phase instruments. This was overhauled in 2024 by raising it from 5 to 9 new regulations and the directives to be effective June 2024, or which has been effective June 2024, but will become operational in 2026. What I'm trying to say is that the law has been adopted, or the regulations and directives have been adopted in 2026, but by the source I got, is going to be enforceable in 2026. So the Common European Asylum System establishes uniform procedures qualifications, criteria, and standards of reception and support from the EU Agency for Asylum. What I'm trying to say here is that the Common European Asylum System gets its support from the European Union Agency for Asylum, and it sets out the criteria, procedures and standards for receiving and supporting asylum seekers. It also established the Eurodac in 2003 as a large-scale, centralized, computerized fingerprint database designed to identify asylum seekers and irregular border crossers. The Eurodac, by its operation, is intended to collect the handprints or fingerprints of the asylum seekers in their first country of arrival. This is to ensure that you don't seek asylum in a country like Italy, then you still go back to a country like Netherlands or Norway to seek asylum. The Eurodac would have captured your fingerprints and your other details, so they will be able to know your country of first entry into Europe, and to enable their record be straightforward so that they don't duplicate information relating to an individual asylum. At least capturing your fingerprint. Every individual in this world has one fingerprint. You cannot duplicate fingerprints. So even if you change your name, they will be able to identify you with your fingerprints that you have already been recorded in a country like Netherlands, and therefore you can't be recorded again in Netherlands or Norway. So the Qualification Directive 2011 establishes uniform criteria for granting international protection, determining when refugee status or subsidiary protection should be conferred. It mandates refugee status according to the 1951 UN Convention criteria, and subsidiary protection for those facing serious harm from indiscriminate violence in armed conflicts, death penalty, torture, inhuman treatment. What I'm trying to say here is that the Qualification Directive of the EU almost has similar status, or was adopted from the 1951 UN criteria, UN Convention on asylum and the issues of refugees. Apart from those issues that I have earlier mentioned, such as protection based on serious harm from indiscriminate violence in armed conflicts, death, torture, inhuman treatment. Others include granting resident permits, work, education access, and social welfare, binding all member states with limited derogations. Now we are going to move to asylum procedures and their directives 2013. It provides fair, efficient procedures, including fast-track border screening procedures, a maximum of 12 weeks for third country claims. Others are effective remedies with a suspensive effect, judicial review, free legal aid, and absolute non-refoulement compliance, despite national variance for individual assessment. By the 2013 Asylum Procedure Directive, they have moved away from the 2011 by new modifications. By this, it means that you can seek asylum in more than one European country. These directives and other legal anchors foster accountability through the Court of Justice of the European Union oversight, though tensions still exist through the Dublin EU Convention of 2024, burdening frontline states and externalization pacts. Then we move to the supernatural strength of the common European asylum system. Because since it is not a law that regulates only the activities of one country, we can now look at it from the supernatural aspect. That is where different countries are being governed by a particular legal instrument, so and an organization. So we refer to it as supernatural. The asylum system of the EU is notable for its supernatural strength. This is reflected by its rigorous
Mr. Michel,
across all
you have
member states,
last
which
5
goes
minutes.
beyond all
Can you hear me? Sorry for
differences
interruption.
to impose uniform qualification, procedures, and reception
Mr.
rules.
Michael?
The supernatural,
Professor
Yes.
Michael, sorry to interrupt you.
the supernaturality also manifests in qualification regulations and
I think there's a
procedural
problem with the internet
regulation,
connection.
which compels all states to grant refugee or subsidiary protection based on objective assessment. Then we are going to look at the implementation challenges. Despite the supernatural rigor of the EU system, challenges of implementation are evident. The Dublin Regulation of 2024, which shifts responsibility to the first state entry, thereby placing a disproportionate burden on first entry states. For example, Greece and Italy are meant to deal with over 40% of 1.1 million applications in 2024, as determined by the case of Total and Switzerland. Though the new pact on migration and asylum on solidarity provides for mandatory relocation, financial aid for migratory pressures, yet current imbalances where frontline states, which are earlier mentioned like Greece and Italy, bears cost of 70% and more, resulting in pushbacks and secondary movements to the north. The next issue we are going to look at is the core tension. They are basically issues that I have already mentioned, but it is important to emphasize on them so that it will bring clarity to this protection. It is observed that the EU asylum system is an expression of a deep-seated conflict. The conflict is between universalist human rights commitments, absolute protection entitlements, sovereignty prerogatives of member states over their territory, their resources, and their admission policies as set out in the Treaty on the Functioning of the European Union, Article 67. The universalist tension is inspired by the non-derogatory, non-refoulement obligation under the 1951 UN Convention. I want to state that the term refoulement means that once a particular individual is in your territory, is in the EU territory, you cannot deliberately return the person to the country where he's coming from, where he said he's facing persecution, or he is facing any threat relating to his life, or is going to be killed, or is going to be sentenced to death. This universalist tension is inspired by the non-derogatory non-refoulement obligation. Universalism is the driving force behind
Professor
the
Michael,
harmonization of the European
can you hear us?
Sir, sorry for interrupting. Your time is almost up. Would you please wrap up?
Can I just round off? Universalism is the driving force behind the harmonization
would you please wrap up your
common...
presentation, Professor Michael? Sorry to interrupt you. Could you please wrap up your presentation, as we had limited time to comply with the conference?
Oh, you mean my time is up?
Yes, unfortunately.
Okay, no problem. Let me quickly move to my recommendation, and I don't want to exceed the time granted to me. By way of recommendation, integrated European-style judicial oversight into the African Court on Human Rights is advisable. What I'm trying to say by this is that the European system have a structured judicial system under the Court of Justice of the European Union. We are recommending that the African courts should have something similar to that. For example, a chamber in the African Court on Human Rights that deals with issues of asylum. Then again, we also request that the AU adopt the expensive definition of refugees into the European standards by incorporating the AU Convention Article 1.2 on public order disturbance criteria into qualifications regulation 2024. Subsidiary protection schools accommodating mass influx into the mass influx for climate nexuses while maintaining individual assessment complemented by the UEA. Then by way of conclusion, strategic rationale by addressing rising African migration to European Union, we request that this is a post-colonial justice issue and regional integration and the sustainable development goal for equitable global norms. Amidst rising African migration to Europe with over 200,000 irregular arrivals, these convergences advance post-colonial justice, aligning with sustainable development goal on orderly migration and the EU Agenda 2063, fostering regional integration through mutual learning, transforming tensions and into transnational solidarity. I thank you for your attention. Thank you very much.
Mr. Michel, thank you very much. It's very comprehensive and insightful presentation. From this corner of the world, we are unfortunately from Turkey a bit ignorant, have been ignorant to what is happening in African continent in detail. So it's very useful for us. Thank you very much. And
Thank
now
you.
I'm shifting to giving the floor to other present panelists. First, Assistant Professor Dr. Işıl Ecelhan. Hocam, floor is yours. Thank you very much.
First of all, thank you for organizing this great conference to Professor Gülüm Özçelik and the organizing committee. So today I'm going to tell you about some historical migrations to the United States and the legal framework for it. So why I am telling you about this, I'm presenting my paper on this because actually the US immigration laws were the blueprint for Europe that we have today. Like the Schengen visa, for example, was established by modeling on the US immigration laws. So actually my expertise is on the immigrant communities, especially from like early 1900s to the 1920s. And actually I also did a lot of research and work for like 20 years on the Turkish immigration to the United States, especially from the Ottoman Empire and also other Ottoman immigrant communities like Armenians, Jews, Sephardic Jews, Greeks, and other ethnic communities from the Ottoman Empire. So we know the United States as the nation of immigrants, always, right? In the like Hollywood movies, in the TV shows, it's always implied that U.S. is welcoming immigrants, always. But was it always like that? Of course not. So when we see the visit of the Italian President Mattarella to President Trump during his first term, we saw that he said, tonight we celebrate the extraordinary friendship between Italy and the United States, and we honor the faith, courage, and countless achievements of our incredible Italian-American community. Those people in that community have done so much for our country. But actually, Italian immigrants were not welcome at all at the beginning of the 20th century, in early 1900s. So the thing the sympathy that we have today for the Italian Americans today actually was because of the public diplomacy efforts of the Italian Americans early in 1900s, beginning from 1900s, even to the 1970s. Many of you know, I guess, the Godfather movie. This was one of the public diplomacy efforts of the Italian Americans, actually, to get rid of the mafia image, because they hated this. And then the American communities usually attacked the Italian Americans because assuming that they were from the mafia. So they wanted to change this image, and then they even, did public diplomacy through Hollywood movies. So maybe you have seen this kind of images from Ellis Island, which was a port of processing for immigrants. Back in the early 1900s, the immigrants would come through ships, through steamships, to the shores of the United States, and then they would be processed in here. There were no consuls who were processing visas in other foreign countries. So they would come here, and then they would be processed through the gates. I think you have, maybe, if you have seen the Godfather movies, in the second part, in the second episode, the child comes to Ellis Island, and then he's processed at the Ellis Island, and he was quarantined for 30 days before being released to New York. And among these immigrants, there were also other immigrants, which is my topic. So you could see, immigrants, even children, Ottoman children, coming to the shores of the United States in New York. So when did this change? Actually, the 1924 Act, also known as Johnson-Reed Act, served as the historical predecessor to the 2025 America First overhaul. So we actually saw the beginning of the immigrant laws today that we have, actually started by President Trump. It has a predecessor in 1924. So while 1924 Act used national origins as its primary filter, the 2025 policies utilize executive actions, high financial fees, and aggressive removal efforts to achieve a similar goal of cultural and political homogeneity. So the immigrant scenes that we see at the beginning of the 20th century changed abruptly by the 1924 Act. So what was the primary reason? The primary reason was to stop Catholics and Southern and Eastern European immigrants coming to the shores of the United States. So actually its idea was to harmonize the American people and remove the undesirables like Catholics, Irish, and Italian immigrants. So the rules set the limit for each country to 2%, and of the immigrant, from that origin, immigrants from that origin at the year of 1890. So why did they set the year to 1890? It was because, for example, immigrants from Southern and Eastern Europe and from the Ottoman Empire started coming after this year. So it limited the people coming to the United States from Turkey, for example, in 1924 to 100 each year. So after they reached the quota of 100, the consular officer would deny visas to Turkish immigrants or Turkish visitors. So actually, this immigration quotas, it was actually, they didn't say any race or ethnic group, but actually it targeted certain ethnic groups and certain religions. So, for example, it targeted Catholics, and you could see cartoons like this. You know, you can see Vatican, and then this is the cartoon was called The American River Ganges, and then you can see that it's like, you know, there's a threat from the Vatican, so they should protect the American soil from this invasion. And the Pope, like, you know, deceit, tyranny, bigotry. So the way to 1924 immigration quotas was paved by these cartoons also. So this is a cartoon from 1924, limiting the gate. Uncle Sam, you know, he's the symbol for the United States. And even in 1891, for example, we saw the lynchings of Italian Americans because of just racism. So, like a couple of years ago, the mayor of New Orleans apologized for the lynchings of Italian Americans. And for example, the statues of Christopher Columbus that we see in the United States were erected by the Italian Americans to show their loyalty to the United States and to show that they were also a part of the United States. So they kind of whitened themselves through these statues. And this is from New York. For example, you know, also the Irish people were depicted like this, like ape-like creatures, and they should be removed from the United States because they are threats to the United States, etc. So the idea was this. Again, an Irish as depicted as an ape. And again, you know, depicting the immigrants as disorderly and violent. And Uncle Sam keeping the gate and returning an immigrant. It is called a stranger at our gate. So interestingly, for example, being Irish was not a very good image for the United States. For a long time, you know, the first Irish-American president was John F. Kennedy. And actually, Joe Biden, when he was president, he also adopted the Irish personality. So he kind of, you know, he said, I'm a son of Ireland, so I will help the Irish-American relations, etc. So you see, you know, how communities actually worked hard in order to be accepted by the community, by the American community in the United States. So Turks were a part of the American immigration, and they were processed through Ellis Island, but for a long time it was not known, so that's why actually I started this research, and then found out that there were thousands of Turkish Muslim immigrants from the Ottoman Empire. And this picture actually is from Columbia University, and this guy, the imam, was the consular imam who was sent by the Ottoman government to New York in 1910 to establish a mosque. And the others are like Ahmet Emin Yalman, Ahmet Şükrü Esmer, Cevat Ayıp Taşman, you know, very influential figures in the early years of Republic. So this anti-immigrant sentiment actually also led to the way that, you know, the Ottoman immigrants, for example, in Canada, they were interned in 1914, assuming that they would do something to Canada, to the British government. So it took a very interesting way in that sense. And this is a cemetery, Turkish cemetery in Worcester, United States. So for many years, actually, people like, for example, professors like Kemal Karpat, who started the studies on Turkish immigrants, assumed that they were just a little, community, and then they didn't integrate, and they eventually returned to Turkey because they didn't want to stay. But through my studies, I found out that, these restrictive immigration quotas, which tore the families apart, and then, also that feeling made them to return to Turkey because they felt not safe. They felt unsafe in the United States because of these quotas and anti-immigrant sentiment in the United States. They even published this, like during the World War I, Turks charged anti-Turkish propaganda in here because they could see that there was a anti-Turkish feeling and they did not feel secure. And even police were raiding the Turkish coffee houses, Turkish houses, grocery stores, etc. during World War I and after World War I. So why I showed this, historical predecessor to the 2025 laws, because actually 1924 laws set the rule for the consular control, before coming to the United States. So in 1924, the United States said that an immigrant or a visitor should be processed through a consular office, not in the United States, but in a foreign country. So they would come to the United States after being processed, and they were allowed to come to the United States. So after that, actually, it paved the way for today's current Schengen visa, right? So there were no processing before 1924. So, for example, if we consider modern mirroring, the 2025 policies reflect the structural exclusions of the 1920s through modern executive actions and enforcement and removal, expansion of expedited removal to the interior, and invocation of the Alien Enemies Act. Maybe some of you know this, President Trump actually invoked this Alien Enemies Act from 1794. So it is a very, old act that he used and found and used in order to deter immigrants. And historical parallel, these actions reflect the aggressive removal of efforts following 1924 quotas. So America First immigration policies really resemble the 1924 and 1920s immigration quota acts. So its motivation was to design an American people, Protestant, white, and remove the undesirables who were Catholics, who were from Southern and Eastern Europe. And that's from presidential campaign of Trump. And One Big Beautiful Act, for example, it introduced significant non-waivable fees and economic barriers, high costs for work authorizations and asylum applications. And fees serve as administrative hurdles to legal presence, similar to historical barriers. And labor selectivity, like 100,000 fees for an H-1B visa. So the result was actually, I think, one of the most maybe human toll of these restrictions for general destabilization of immigrant communities. And also citizenship and 8 executive orders challenging birthright citizenship. So actually these laws of President Trump actually was designed to bypass the 5th and 14th Amendments of the United States. So the 1924 Act was driven by nativism, and the acts that we see today, implemented by President Trump, is for like nationalism. And the goal of the 1924 was to protect Protestant American values from unestimable populations. So we see also on TVs in the news, like, the ICE police officers raiding immigrant communities, right? So this happened actually in the 1920s. It was called Palmer raids. The target was the communists because of the raid scare. So even today, when we see the ICE raids, it had a predecessor from 100 years ago. So there's a cartoon depicting the Palmer raids. You can see it's read traitor, spy. So it will just categorize people who they didn't like as spies or traitors, and then they would remove them, and then they would put them into ships and sent back to their country. And ICE raids, which kind of has a similar motive. So the Palmer raids were initiated by Bureau of Immigration, Department of Justice, and the ICE operations are by ICE. And the motivation was the Red Scare. And now, Trump said there's an invasion of immigrants, and it's a national security, so we should invoke the Enemy Aliens Act. So the legal shortcut was administrative warrants, no right to counsel, and for today, expedited removal, Alien Enemies Act. And it resulted in breaking up of Italian and Jewish communities and also Turkish communities. And today it resulted in destabilization of mixed status families. So today's legal tool, it's unbelievable, but it is the law from 1798, the Alien Enemies Act. And in 1920s, they used manual enforcement, and local police and inspectors, physical warrants, limited data. But today, it's high tech, and the tech-enabled purge, ICE facial recognition, biometric tracking, and interagency data sharing. And in 1920s, for example, Palmer used he was the Attorney General of the United States by then. He used 1918 Sedition Immigration Acts to bypass the courts and use administrative deportation against radical groups. And in 1925, we see the tactic as the proposal says to use 1798 Alien Enemies Act to bypass the courts and use summary removal against modern groups. And he could easily label some groups as terrorists, as gangs, cartels, to remove them from the United States. So both eras, if you compare them, represent a weaponization of migration management to achieve cultural and political homogeneity, and we see the same thing during Trump administration. And diaspora impact for groups like Turkish diaspora, these shifts create cycles of exclusion, and long-term effects, disruption of integration, and increased socioeconomic instability. And thank you so much. So we see that, although some people believe that history doesn't repeat itself, but actually repeats, the same motives, the same sayings, like, for example, Trump says immigrants are invading America. And then when I was reading the historical articles, historical newspaper archives, I saw many articles saying Turks are invaders of the United States back in early 1900s. So you see the same rhetoric, actually. Even I found a student paper titled "Turkish Invasion" in the U.S. Yeah, back in early 1900s. So I think this kind of like leaders just go through the archives or historical books, and then they find like legal loopholes to to support their rhetoric, and then we see the results today. Thanks so much.
Thank you very much, Dr. Işıl Hanım. It is very, I listen to you as if I am watching a good movie enriched by cartoons and historical pictures and anecdotes, and we see that it is very intercultural thing. I remember that during the First World War, there's a saying that Netherlands was invited by the armies, but Belgium was invaded by migrants or refugees. So these themes are quite common across the continents. There are very common things. I was relaxed at the beginning because I was informed by young colleagues that this is the last session, so I always didn't check the time. So I will also show you flexibility with your kind permission. But these are very good, interesting teaching presentations. Thank you very much. Please, floor is yours, Dilahan Hocam.
Okay. Thank you so much, but I promise I'll keep it under 20 minutes because I know it's been a long day, and I hope you have some more patience for my presentation as well. Before starting my presentation, I'd like to note that all names displayed in the slides are pseudonyms, and that the personal details of the participants are kept to a minimum. Since my paper is based on one of the empirical chapters of my PhD thesis, it brings refugee experiences forward and also briefly introduces one of the main arguments that I make in my analysis, inherent in the Greek asylum system. But for those who are unfamiliar with the asylum adjudication in Greece, I'll first try to offer a brief account on its development and current state. Yet before all that, I'd like to start my presentation by quoting one of my participants. The excerpt here belongs to Aziz, a young Afghan refugee who spent 6 years to be recognized and has been working as an interpreter in more than 10 different organizations in Greece. The first couple of sentences, he describes his own experiences and how he perceived Europe as a singular entity, a unified legal space, a paradise, a safe haven for refugees. Unfortunately, he was disappointed by the system he encountered in Greece. The following section, though, illustrates a more realistic comprehension thanks to his experiences within the humanitarian sector. In his point of view, the Greek asylum system is a labyrinthine one. It is complicated, tangled, and confusing. Looking at this diagram provided by Ekre, you may think that it can't be that confusing. A system which includes a first instance assessment and administrative appeal procedure, an opportunity to go for subsequent application, and at the very end, a path to annulment. However, Aziz was not the only one provided me a description like this. I've heard this from many others, including NGO lawyers with years of experience in Greek practice. But why is it so? By using the bottom-up insights I gained during fieldwork, I've been working on an explanation of the interrelationship of complexity and ambiguity of asylum governance in Greek law and policy. But let's let's try to touch upon the top-down design and evolution of the system in Greece. This timeline is helpful to understand some of the key moments. Within my time limit, it's not possible to go into the details of each. However, it's still worth mentioning a couple. I believe the significance of the European Court of Human Rights, MSS versus Greece and Belgium, is known to many in this room. The judgment was the formal recognition that Greece has been a precarious environment for people on the move for a significant time. So, and to this day, lawyers use this landmark case as a key reference in terms of minimum standards for both reception conditions and fairness of asylum procedures. For the case of Greece, it is considered a milestone since it has started a series of law reforms in order to address the deficiencies of its asylum system that the European Court condemned. We observed that around the same time of the decision, the Greek government finally established an autonomous asylum authority. Prior to this, asylum fell under the authority of police, particularly to the Aliens Bureau. Despite being established in 2011, the Greek Asylum Service didn't start its operation until mid-2013. Regarding the work of this new asylum authority, there have been comments saying that its operation was self-taught and almost experimental sometimes. Before institutional practices had been solidified in 2015 and 16, Greece faced a new migratory influx and a growing unprecedented pressure on its asylum system. And the country proved unable to meet the resulting demands of the so-called crisis that we are all familiar with. And managing the crisis and responding to the needs of people became possible only through support from multiple EU agencies, one volunteer assistance from Europe and beyond, and maintaining the country in a transit position by keeping the Balkan route open. At that time, a leftist coalition government was in office, and they demonstrated a commitment to overhauling the asylum system and adopting a human rights-based approach. Yet this approach did not stop them to implement the infamous EU-Turkey statement, which was widely criticized in academic circles and by many human rights groups. And then the 2019 elections resulted in a government handover from Syriza to New Democracy, a right-wing party. For asylum law and policy, this change of government meant a shift from a humanitarian approach to a securitization one. In the following period, we witnessed 5 important legislative reforms that are mainly focused on excluding more and more people from qualifying for the refugee definition in Greek practice, particularly by invoking multiple safe country concepts available via EU asylum framework. In Greece, one's country of origin and the countries she passed through quite determine how lengthy and complex her experience will be within RSD procedures. Since the system prioritizes exclusion over protection, these concepts function as filters at the very beginning of the legal process. If someone falls under this category, a different procedural path is applied for her asylum claim. Whilst people coming from safe country of origins are subjected to accelerated procedures, the people for whom the system considers a third country safe go through an admissibility procedure. Only when they pass through the legal thresholds of these fragmented set of procedures, could they be assessed on eligibility? Secondly, what makes the system more fragmented is the location of arrival. As you can see from the table, arriving on the mainland, on the islands, or in border zones results in various procedural rules, and most importantly, different time limits and deadlines for RSD. You may also remember it from Gökçe Hoca's presentation earlier today. In terms of people's experiences of RSD in Greece, this indeed creates a dichotomy between the mainland and the islands. As Aziz rightly said, even as a lawyer, it is really difficult to keep up with the rules applied and take action accordingly, considering that access to legal support services is also extremely limited within this spectrum created by one's location of arrival. Exercising right to seek asylum becomes very tricky because people usually do not receive adequate information about the legal space that they are entering. Speaking of legal information and guidance, asylum seekers' access to legal aid also needs to be addressed. In the Greek asylum system, the state only offers free legal aid at the second instance, namely appeals. To provide legal support in other stages of the asylum process, legal NGOs step in. These organizations must meet the NGO registry criteria imposed by the government to be able to operate in the area of migration and asylum, which basically functions as state surveillance. If they do not meet this criteria, they cannot operate inside the camps, and their access to potential clients becomes challenging, and in some locations practically impossible. The only way to overcome this restriction, if they are not included in the official registry, is hiring Greek qualified lawyers into their teams, since they are exempted from the relevant criteria thanks to the legislation on lawyers and legal profession. NGOs' role to fill in the gaps left by the lack of state-funded legal aid at the first instance particularly is vital, because the first asylum interview in the Greek asylum system stays at the core of the whole procedure, and it is incredibly hard to reverse the facts of the claim when they are not established properly without profound legal guidance early on. A further eligibility interview is possible in a subsequent application only if there are substantially new elements to the claim, and in the appeal process, in principle, there are no oral hearings, therefore no further chance to present one's story before the decision makers. Even if that has been possible, you can see the ratio of rejected cases before the appeal committees in this table. Final point to make in order to understand the current state of the Greek asylum system is, of course, the application numbers. Numbers show a steady increase in asylum claims made in Greece, signaling that the country is not a transit one anymore, and we are talking about the numbers surpassing the infamous crisis, actually. I hope these basics were helpful for those who are unfamiliar with the national asylum context. Now I'll return to the questions where I discuss lived experiences of RSD in Greece. My paper is structured in three main sections to organize refugee experiences in a coherent way before, during, and after RSD procedures. And overarching argument I make is that some refugee behavior may complicate further a procedure that is already that already has a complex design, and these behaviors can be fueled by agency and resilience if the person takes action, and by passivity or trauma if the person avoids initiative. Before arrestee, the first thing that shapes refugees' experience and behavior is the lack of awareness on legal aspects of asylum and also an understanding of national context. Zahra, a survivor of human trafficking from Sierra Leone to Iran and then to Turkey, for instance, was so naive to even ask what is Greece because that was the first time she heard about this country. Second, the experiences and cruel treatment they receive in the camps are an important factor shaping their behavior. They usually deem this matter as a direct attack on their human dignity and also a disrespect to their human rights. There are also instances where they are discriminated by Greek officials and therefore their relationship with their host state gets severely damaged from an early stage. As a result of these experiences, what usually happens in refugees' perception of the Greek asylum system is a mismatch between their expectations and reality. This mismatch triggers behaviors such as lying about the age, linked to feeling unsafe because they want to be assigned to the minors section inside the camps in order to protect themselves more, or avoiding fingerprinting because they know that once they give fingerprints on the islands, there can be a geographical restriction on them to leave the island or Greece in general. And lastly, taking initiative to relocate themselves, either within the country or to elsewhere in Europe. All of these result in procedural complications that are not easy to overcome without legal intervention and therefore legal representation. During arrestee, again, it is possible to identify a distinct lack of awareness and information regarding the procedure among asylum seekers. Here, there are serious deficiencies on the side of Greek authorities. When NGO lawyers try to cover up, then there's the issue of trust. And due to many traumatic events that they experienced both during the migration journeys and in camp life, it is very difficult for these people to build trust with anyone, including NGO lawyers. If they have access to any NGOs though, because due to the remoteness of the camps, regardless of being on the islands or on the mainland, reaching NGO offices is a big challenge, yet perhaps the biggest challenge is finding capacity in these organizations to receive the legal support they need. On top of capacity, funding is a constant issue for legal NGOs to keep their operations running. This also affects the working conditions of lawyers to a great extent. And there are also some poor practices conducted by some organizations or individual lawyers. Unfortunately, some of these practices are not trauma-informed at all. So what do all these experiences during arrestee produce then? Well, they result in a general distrust in the legal system. This even extends to the lawyer-client relationship. Therefore, asylum seekers do not open up easily. They keep information from their lawyers, and sometimes they suddenly change their stories during the asylum interview. As you can imagine, this creates serious issues with the credibility of the claim. Yet still, even if they succeeded in their asylum application and got recognized, and actually most of my participants did, they experience a sense of disorientation within the legal system, which is a concept I borrow from Tazioli's work. Feeling disoriented makes it challenging for them to feel safe, start a new life, and eventually build a sense of belonging in Greece. After arrestee, after recognition, already limited legal support mechanisms become scarce because, as Efsun says here, it is always about what NGOs can do and cannot do in terms of their capacity, funding, and mission statements. And the focus is usually on providing support only during the asylum procedures. Two important issues that I came across during fieldwork were people facing problems with renewal of the status and documentation, and single parents having to deal with custody problems. I'm mindful of time, so I'm not going to go into the details of this at the moment. But I can say that the experiences they have after arrestee leave them with a continuous struggle with law. When this is added to all the other problems that they face with integration, and when they would like to exercise socioeconomic rights in Greece, the whole picture gives them more than enough reason to go for secondary movement. In my analysis of the problematic state of the Greek asylum system, I argue that there's a top-down complexity created by pluralistic reality of EU asylum law, imperfect law reforms, and finally operations of various national and EU-level authorities. Nonetheless, refugees can also contribute to this complexity from the bottom through certain behavior, unwittingly or not. Having experienced this complexity, shaping their relationship with the host state and shadowing their daily lives, they cannot see a proper future for themselves in Greece. What I mean is a future that they feel welcomed, as in Ali's words, or a future that their rights are respected as is wants. Eventually, for the state, the complexity of the system serves their main end goal, deterrence, which keeps Greece in the transit status, although more people arrive in the country, claim asylum, and try to stay longer there nowadays. That will be all. Thank you very much.